it's Lisa from Been There, Got Out. Tonight's interview is part two with Chicagoland family lawyer, divorce attorney, Raiford Palmer. There he is. Thanks for coming back. I know I messed up the time last month, and this time we're going to get a whole hour if you want to fill it up.
No, that's
Pretty
great.
sure you can do.
I appreciate it. Thanks for having me on the show.
No, my pleasure. You know, I have to say that we've gotten some compliments lately. Just one a little while ago from someone saying, I love watching your show or whatever this is called, because I love hearing different experts' opinions. It gives me a totally different perspective on what to really expect when I go to court, because, you know, people have all these ideas about what it should be like. And then there's the people who are in the trenches who can say, yeah, but this is what it actually is like. So it can help us all strategize and plan better and not be as blindsided, and you know that education is our number one thing. So thank you so much we've done a few collaborations now.
Yeah, that's my pleasure. Thanks for having me on. And I love what you're doing for your audience. And it's all about education. That's what I'm all about with my book and what we want to do with our law firm. And so I'm always happy to spread the word and help people get a better perspective about something that's so important in their lives.
Yeah. Okay. So with that, Rafe, why don't you formally introduce yourself, and then we'll pick up where we left off and then some.
Sure. My name is Raiford Palmer. I'm the managing shareholder of STG Divorce Law in Chicago. I'm also the author of the best-selling book, I Just Want This Done: How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds. It's on Amazon in every format, paperback, hardcover, Kindle, ebooks available anywhere where ebooks are sold, Apple Books, Nook, and also audiobooks. If you're a big fan of Audible, it's on Audible. If you have an Audible subscription, it doesn't cost you anything. It's just some of your membership points. So thank you for letting me talk about that. Yeah, so I've been a divorce lawyer for over 20 years. I've been an attorney since 1994, and I did other things before I did family law and divorce. So I bring that perspective to handling divorce law. I'm also a divorced father of 2 sons, and I've been since remarried. So I have that perspective as well.
Oh, interesting. I don't think I knew that. And it's funny seeing you show your book, because Chris, like so many of our legal abuse support group sessions and with clients, he'll mention your name and he'll take it down off the shelf and we'll show it, and they write it down, take a picture, and then it goes back up. So we say that even though you don't have like tons and tons of high conflict divorce cases, your book still applies to many, many of the cases that our people deal with, which are always high conflict situations. So with that, with the title of your book, you know, everyone wants to just get it done. So before we talk about what they can do, because I know we'll get to that, but I'm going to throw this at you, and I didn't prepare you for it, but I'm sure you can answer. What are some mistakes that you see that end up dragging out the process? So what are some things that people do wrong? And I'm thinking about even like red flags that you see in a client, or types of behavior, or from the other side that you're thinking, oh no, this is not going to be normal. This is going to be one of those difficult ones.
So hiring the wrong lawyer. So hiring somebody who doesn't have the right mindset, who is a World War III kind of rock'em sock'em robots, like swamp creature lawyer that I talk about in the book.
Okay, tell us about that. Because a lot of people are like, I got to hire a pit bull.
Well, the problem with pit bulls is once you let them loose, they just start biting everybody and they don't stop. And so pit bulls are, you know, some aggression is fine. You know, sometimes you need to fight to protect somebody, but there's a measured response that's important rather than just fighting all the time. And I think and I talk about it in the book, and I've talked about it on my social media, there's a tendency to think that fighting is good, that I need protection, so I need a fighter. Well, sure, that's good, but fighting just to fight is not good. So having an end goal in mind, knowing the problem with some of those attorneys, either by training or by their very nature, is that they aren't carefully evaluating the case. They aren't instructing the client, informing the client properly about the realistic chances of success and the realistic costs to get to that place. And so the client is misinformed or uninformed, and they just do what the lawyer tells them because they don't know any different. And the lawyer walks them down a path of spending a ton of money and getting embroiled in a big battle when that may not be the best thing for them ultimately. Or maybe they should have gone in direction A, not direction B. And instead the lawyer just keeps pushing the battle button, like, let's file this motion, let's file that motion. And, you know, understanding the realistic limitations of what can be accomplished by a court process is so important. And I don't think there's a lot of education going on around there about what's realistic to expect and how much it costs.
Yeah, and as you say that, I'm thinking actually of my ex's attorneys who I feel like have been, I don't have sympathy for him, but they've been financially abusing him worse than anybody ever could, because I feel like they're making him think that if we keep this going, that somehow he's going to be able to squirm out of court orders or not have to pay. And he's now accruing a lot more interest and penalties from their documented pattern, which the court has noted of, quote, creating confusion where none exists. So
Yeah.
by his attorneys delaying the process, I mean, certainly I've suffered, but being pro se, I've suffered less than I did in the past when I was paying tons of money for people to deal with it. But it's like their own client is now suffering because he's paying the price of counsel, which is saying, oh no, keep going, when if they had just said follow the orders, it would have been a lot cheaper and done a lot quicker.
Well, right, and what's the logical end game? So the guy's ultimately going to lose. Like, eventually it catches up with you. If you owe an arrearage in child support, you owe the arrearage.
That's what we're dealing with.
I don't know where you're going with that, you know. And so when a client calls me with one of those things, the best thing you can do is tell them the bad news. And it's not fun to tell people bad news. Sometimes people don't hire you because you're not telling them what they want to hear. But I think it's akin to being a doctor-patient relationship, where a good doctor tells you objectively what your chances of success are with the surgery, how much is it going to cost, what's your recovery time going to be. And so you can make an informed decision and know, okay, here's the risk of surgery. I might die or something bad might happen. Here's the chance of success. Here's what the good stuff is that could happen, and here are the costs. Well, if you don't know that stuff, you're just going to go get the surgery and spend the money because you only think good things. I don't think all lawyers, these lawyers are not necessarily all evil, but the training, and I talk about this too, the training is that basically we're taught about being litigators in law school. They don't spend very much time teaching you alternative dispute resolution. They teach you all about the court process. Well, so we're trained to deal with trials and litigation. So part of our training is that. And the other thing is our ethics rules say that we're supposed to zealously represent our clients. That's the magic word, is zealous. Well, I think lawyers use that as a shield and a sword. So it's easy to say, file the motion. You know, my husband did X. And you say, well, go file the motion and we'll punish him for that. Okay, but did you tell the client that it's going to cost $5,000 to file the motion and to have the argument? And are we spending $5,000 on a $3,500 problem? And because the $5,000 is real money that's going to get spent on those fees to try to chase something less potentially. So that's where the cost benefit analysis needs to get done. And I think it's not done enough.
Right. That was going to be my last question to you, because we did that as the first question last. Yeah. So anything besides like an attorney that's not really skilled or telling the truth about the reasonable outcome, what other things do you notice that might drag out a case? And in my head, I already have a couple of red flags.
Sure. People that are emotionally invested in the situation such that they're not thinking clearly. So a lack of having counseling, a lack of having perspective about your situation, so that you're so angry at the other person that you're trying to use the court system to damage them. By the way, it's one of the most inefficient ways to hurt somebody is to spend money on a lawyer to try to do it for you. It's you're cutting your own throat half the time. And I don't know that, maybe they don't care, maybe they don't know, but you're spending your own money on it's a very inefficient way to punish somebody.
Yeah.
And it never comes. Yeah, and it never comes out the way you think it will. Even assuming you have harmful intent, it's a really lousy way to try to hurt somebody. You're just spending money and wasting time. and you're hurting yourself in the process. But anyway, so I think being emotionally invested, thinking the court process is going to be the avenue for you to feel better, is you're never going to get that. You're not going to get that wonderful outcome from the court process that you feel vindicated, that the other person is punished, etc.
Oh yeah, and we see that all the time. And when you were talking about regarding mental health and being so emotional, I was thinking, and we talk about this in our own book, which is coming out in 2023. One of the red flags that something's going to be a difficult divorce, and my own former, my divorce attorney for that first year years ago told me, was when someone has an addiction. He said that when someone has an addiction, they're not, it's the same thing you said with mental health, they're not thinking about what's in their own best interests, and they're short-sighted, and they're not thinking of the consequences. So if they can't even have judgment, like clear-headed judgment about what's going to be best for them, how can they make good decisions that are going to affect everyone else? So it's really, really hard to deal with someone who's not in recovery. I mean, you have an addict who's in recovery, but someone who's addicted in all kinds of ways, it's going to be destructive.
Well, sure. And the addiction is draining, mental energy, emotional energy, money, time, physical, it's damaging people's health. So yeah, they're not going to be in a good place to work on issues in their divorce, depending on the severity of the addiction. Yeah, of course, that would be a concern as well. And so I guess I wanted to address one thing and to say, it's perfectly acceptable to be emotional about a divorce. It's an emotional time. My blood pressure was like 150 or some crazy thing for the several months I was getting divorced. And you're going to be emotional. That's understandable. It's losing control of your emotions and having emotions rule over your intellectual mind, and you're not making sane decisions, or you're not making intelligent decisions about your divorce case because the emotions are blocking. That's what I'm getting at. That's when it's getting to be a problem. So being emotional in and of itself is totally normal, but it's when the emotions are conflicting with rational thought, that's what I'm getting at.
Yeah. And that makes me think too, another red flag that I remember, and I wonder if this is your experience, is when someone is dealing with emotional abuse and, psychological issues where they can't move forward with the process. You see that where they decide they're going to get divorced, and then it's like a no offense to you football fans, it's like a football game to me, like stop and start and stop and start.
Right.
So my old attorney had said it's very hard to work with victims of coercive control because they keep getting sucked back in. A lot of our people are often told, well, let's not even use lawyers, let's do it this way. And then in the meantime, they have a lawyer, or they're pressuring them into making agreements that aren't in their own best interest. Do you see stuff like that?
Absolutely. And the analogy I use often is a bridge analogy, where one person is farther along the emotional bridge towards divorce. And you could call it the 5 stages of grief, anger, denial, bargaining, all that stuff, and acceptance. But call it what you will. In most cases, people are in a different emotional place along that progression. And if somebody's much farther behind than the other person, they're having trouble coming to grips with the reality of the divorce, and they may drag their feet, delay, not participate in the process, and cause a lot of trouble in the divorce process because really they're emotionally not ready. So they're holding back in one form or another, either by fighting or inaction, whatever, not participating in the process, so that it slows the whole thing down. The person that's eager to get divorced is frustrated because they're farther along that bridge and they're ready to be done, and the other person's not. And that can toggle back and forth. People can, like you said, the football field, it's like the bridge. You move farther ahead and sometimes you fall back. And so you might make some progress and then a step back and forward and back again. And that can be very challenging in a divorce situation.
Yeah, and when you said the thing about not participating in the process, we sometimes see with our own clients where they are so overwhelmed that they cannot do the paperwork. So
Yeah.
for example, discovery, interrogatories, that seems to be, and I know with myself, it's like, oh my gosh, how am I going to do this? And people have the papers laid out all over their homes and their lives are in chaos. And they're just like, I can't even get started. But
Sure.
by not getting it done, then it's delayed and then it can affect the foundation of the case, right?
Well, absolutely. And it's understandable because we are afraid. Fear is based on the unknown. We get afraid of what we don't know about. Well, what we don't know about when we're in the middle of a divorce case is what's going to happen to me? What's going to happen to my kids? What's going to happen with the future? Am I going to have a place to live? And these things scare the hell out of us. So we have a lot of blanks, in sort of our future plan. And that's scary. Well, one of the things we do subconsciously or unconsciously when we don't like something is we avoid it. I mean, I'm a pretty famous procrastinator too. And so we wait and we wait and we wait. And we're not making progress. And instead, a lot of times we're compounding our problems because now the lawyer needs information from us. We haven't gotten it to them. Now maybe you blow a deadline and you get in some trouble with discovery, potentially discovery sanctions where your lawyer or you get potentially fined for legal fees because you're taking too much time. So yes, you can get in a situation where your fear is blocking your own progress, and it's overwhelming. And understandably, because like the financial forms and the other things that lawyers send people to fill out, they are complicated. And if somebody is potentially not as financially sophisticated as their other spouse, maybe your spouse was the one who paid the bills and they did the taxes and everything. And now you're in a situation where your lawyer says, hey, fill out this financial affidavit. And it's, 8 pages and requires all kinds of documentation. And that's overwhelming. And
Yeah.
one thing that a lawyer can do to help is try to provide some guidance and some information and also some help from the lawyer or their staff to walk people through that process. So we provide like a video explaining that thing along with it so that I do a video they can just click on the link and watch it to get an explanation of what the heck they're looking at. Because, we've seen hundreds of them, but for most people, that's the first one they've ever seen.
And that's so helpful because I think about, with a number of our people where they say like, I just got handed this thing. And I know I myself have done so many financial affidavits because where we are every month, where you have a case open, if it's anything to do with money, you just have to redo those 8 pages.
Oh, really monthly?
So,
Okay.
yeah.
Yeah,
So,
for us, it's like 2 or 3 times during the case. It's like beginning, kind of middle, and end.
No.
Yeah.
No,
Wow.
but again, this is years for me. So,
Yeah.
they want it updated all the time. But our clients feel like I don't have any idea of how to do this. And then often they're trying to call the lawyer and then the lawyer doesn't get back to them. So I like hearing that you have videos, almost like frequently asked question videos that people can watch on their own time and just be like, okay, this is how you do it. It makes things, having that clarity makes things so much more helpful.
I'm trying to do a whole lot more with the social media is sort of, sound bites. So you can't get into depth in much depth on TikTok and Instagram, but I'm recording more YouTube videos so I can go into depth on topics and put them on the STG Divorce Law channel, which is Illinois focused. But then I just, doing one about what a petition for dissolution is, with, a complaint, like the initial document, explaining what it is, what not to freak out about. What does this thing mean? What does it do? Should you file first? Questions that we get asked all the time. So it takes time to create these videos, but I'm trying to produce about one a week or one every couple of weeks and get those out there so that there's a body of information available for people who want answers to these questions. And it is hard to reach lawyers. They're busy working on casework. And a lot of lawyers don't realize that the most important part of the job is answering the client questions. I use what I call a library analogy, which is, this is not a knock on librarians, by the way. I love the library, but I have this vision that the day they open the library, the librarians went in there like, this place is perfect. All these books are here. This place is amazing. Then the people start coming in and mess up the library. They take the books, they mess up the books. They don't bring the books back. They put them back on the shelf in the wrong order. And the librarians start to hate the people that come into the library because they're like, if these people wouldn't come into this library, this thing would be great. And I think at some point lawyers get frustrated, and there's this sort of, like, they don't teach you about clients in law school, folks. They teach you about the law, and they teach you about being a lawyer and writing stuff and doing lawyer stuff. And so when the clients call with their concerns and questions and everything, when I started out as a lawyer, I thought, what the heck is this? This is taking all my time talking to people on the phone. And you realize that's actually my job. That
Yeah.
actually it's, and when you come out of law school, you think it's 90% law, 10% people, maybe even 1% people. Then you realize, wait a second, they're paying the bills and they're the person I'm solving the problem for. And if I don't talk to them, I'm not going to have a job for very long. And answering the questions does solve the problem. So
Yeah.
it does lead you towards the solution. So then I learned it's the other way around. It's 90% people, 10% law. And once a lawyer realizes that, that's when they start to become very successful.
Yeah, and I have to say, I love your library analogy because I'm on the board of our library, and I started and ran our book sale for 16 years. And it's the same thing. I tell the volunteers we got to make everything look nice, and then everybody comes in and messes it up. But your job is to keep putting it back, and that's why you're here. Like, that's why I have 18 of you putting stuff back, because that comes with the turf, like making a mess. So it's the same kind of thing. It's like all the questions, like that's to be expected.
This job would be a lot easier if these clients weren't calling all the time. I could get some work done. You know,
I know, if they weren't human.
You realize that's the job. That's the job is talking to people, communicating about their goals and their concerns, and then that also gives you the guidance you need to get the legal work done.
Yeah. So now I'm going to talk to you about something that you said to me a while ago about how lawyers aren't trained in communication. And you said that it was really helpful to go from investigative mode into counseling mode. So tell us what that means. And also don't forget to talk about empathic listening.
Sure. Okay. So early on as a lawyer, you're trained in being more of an investigator, and you're trained to be analytical and being a problem solver. And law school attracts those types of people, naturally. If you look at the LSAT, the law school admissions test, there's a whole section called logic games where you solve these logical problems. And there's a reading comprehension section and a writing section. So school itself attracts a certain kind of analytical mind. It's the kind of people that are interested in going to law school, they like this stuff. So you go to law school and you're reading all these cases, you're studying statutes, so state laws, federal law, you're studying the cases that courts have decided based on the law and the facts, and you're learning trial practice and litigation, and you are learning to ask incisive questions that get to the point. So you are trained in evidence class to learn how to get things into evidence at a trial. So there's rules about what you can ask and what you can't ask of witnesses at a trial. And that's how the information gets conveyed to the judge and the jury. And you hear people in TV shows say objection, and then there's responses to objections. Sometimes the judge says overruled or sustained. So we're trained to tell a story through asking a series of questions, and we're trained to be efficient and try to get to the point. Not all lawyers are good at it, but that's the goal. And in investigating cases, we are supposed to be asking detailed questions, extracting the information we need to make sure we understand the facts, to fit the law, to understand what the outcome should be. So with that training, your instinct, when I started doing consultations, so I started out doing personal injury work, working for insurance companies, and you rarely talk to the clients. You would talk to clients before depositions, maybe initially to hear get a statement from them about the nature of the accident, and then preparation for trial. Very little contact with the clients. So when I moved into doing other types of law, like business stuff, and I started doing divorce, I was very surprised to learn that there was a lot more discussions with clients, and that also I was bringing my deposition skills where I'm asking all these questions about accidents and time and distance and speed, and I'm almost like a detective. And you're switching over to a human type thing where people are talking about real life problems and their marriage breaking down, and these serious issues. And so they start saying, well, my husband cheated on me, and my instinct is to say, how much money does he make? Which is horrible. And you know, yeah, it's good to know that, because then I can think about support, maintenance, child or alimony, child support, those, so mechanically you start thinking, you go through your computer routine in your head. Well, I need to know their incomes. Do they own a house? Do they own another house? Does somebody own a business? What about the kids? Talking about parenting and breaking down all these facts. Well, you realize that that's really a horrible way to start off a conversation. And what you need to do is let people unwind and tell their story. And I did a sales training program with another lawyer many years ago. And she was telling me in this program, you have to be an empathetic listener. And I thought I was a good listener, but I mean, lawyers like to think they're good at that. And I never thought I was bad at it. But then she said, you need to spend 45 minutes of the 1-hour consultation just listening. Well, it was the other way around for me. I would listen for a few minutes and start asking questions and try to anticipate everything they want to know. And I just start talking and then ask another question and maybe another question and kind of go through a checklist. And it put a wall between the client and me and the other lawyers in our firm. So we realized the best thing we could do is actually just shut up and listen.
So what did you notice when you started doing that?
We learned a lot more. By letting people tell their story, you learn a lot of important things you might not find out by asking questions. And you learn about what people's goals and fears are much more directly by listening to people tell their story, because typically their goals will come out.
Mm-hmm.
They'll say, I'm worried about X. I'm worried about my kids. I don't know where I'm going to live. So, goal is I want to know where I'm going to live. I want to make sure my kids are okay. And you start identifying those goals and fears. And that's something I learned in my collaborative law training as well, was to make sure you ask clients about their goals and their concerns at the outset so that you know how to frame up the whole case, because the nuts and bolts are all fine, that's support and division of assets and all that stuff, but you want to make sure that you're trying your best to let your client know, are your goals achievable? What's realistic to expect? What will it take to get there? And maybe some of the goals aren't realistic. So doing the cost benefit analysis, explaining to the client what's realistic to expect in the range of potential outcomes. And that takes careful listening to the goals and concerns.
Yeah, and I'm thinking too, I think we've said this in a prior collab that we did, but so Chris and I went to Barbados and trained attorneys on dealing with clients who are victims of coercive control, because they're a growing number. And, one thing to keep in mind for attorneys is that often an attorney is the first person that somebody leaving one of these relationships gets to talk to. They don't know. I didn't know about a domestic violence center. I didn't know about any other resources. So when I found a divorce attorney after a 20-year relationship, it was like he was the first one. And luckily, I got an excellent divorce attorney who had a lot of social emotional skills.
Sure. And
I felt like immediately so relieved. And I think that made me choose him because I felt understood.
Yes. People want to feel like they've been heard. And I think a lot of lawyers are too quick to jump to the just the facts, series of questions. And it's like they're checking off stuff on a list. And so we used to do this. So the first thing we did when a potential client would call the office, our staff would send them like this 8-page monster questionnaire. And we didn't know any better. It's just what we always did. And we'd say, well, bring this with you at the time of the consultation. Well, we realized later, this thing was super intimidating. It was like, tell us about your kids, what's your income, last 5 years, all this investigative stuff. And we realized we were throwing up a wall between ourselves and our potential clients. We were creating barriers for people rather than making the transition into our office easy. And now we have a very minimalist, form that they get online. That's a web form that's real brief. And it's like, we just want to know, do you have kids? What are their ages? Do you have any quick outline of your property? And it's really short and sweet. It's like 5 questions. And so we at least know, kind of oriented to what we're going to talk about. That's all we need for the consultation, not this monster form. It's like filling out a tax return. And then we would when the client would come in, we didn't really know any better. We'd have that form in front of us and basically fill in the blanks. Well, it's really not a good way to get at the heart of what's concerning people.
Yeah, and also I think about the perspective of many of our people is they're already overwhelmed. So to get an 8-page thing, it's like, oh, I can't handle this.
Right.
Like I just want to go in and talk. So I think your new approach sounds much better.
I read this book by the gentleman who founded Clio, which is a program that's a billing software plus case management software for lawyers. His name's Jack Newton. He wrote a book called The Client-Centered Law Firm, and his company did a lot of research on lawyers and why certain lawyers were successful, why others weren't, and how the marketplace was changing, not just for lawyers, but more broadly. And because of the internet, we know so many businesses have changed. The travel industry is radically different. You used to be able to go to the travel agent on the corner. That's how you bought tickets and learned about traveling somewhere. You used to go to the corner accountant to get your tax return done. Now you can go to stuff online and do your taxes on your phone. A lot of people can. And real estate has changed radically, with realtor.com and all that access to information. And similarly, that's happened in the law business. And you can buy a car on your phone. And lawyers need to understand, to help their clients appropriately, we have to adapt to those changes as well. And clients have a right to demand access to information that they're getting from their other business providers, other service providers. The person that does my hair texts me a reminder I get a haircut, I get a text. Well, we didn't, we weren't texting anybody. And I went back to my people on my team and I said, if Melinda can text me, why can't we text our clients that their appointment is tomorrow? And it's like things like that people expect now. They deserve that from their attorneys too, to smooth out. The process is hard enough. I want to try to remove barriers.
Before the first time we talked, you texted and reminded me that we had our Zoom meeting, and I was like, oh, this is so nice, because we're in different time zones.
Yeah.
Yeah, so it is really helpful.
But understanding the client's perspective and what are they going through is going to make the client's experience much better. And understanding we have a job of an educational job, and also a job to provide resources for people. If, like you said, we're kind of the first responder. So can we recommend mental health professionals? Can we recommend a financial person to guide them? They might need some advice from a financial person. Divorce financial planners can be awesome. Counselors are amazing. We're big fans of mental health professionals, both licensed counselors, psychologists, divorce coaches, immeasurably helpful in the divorce process. And for lawyers, exactly. And for lawyers, understanding the difference between a lawyer thing and a counselor thing is super important. And in the beginning, I didn't recognize that. I just thought it was part of my job to listen to the client's kind of concerns and complaints. And I would give them some common sense answer that I thought was good. Stuff my dad told me when I was a kid, and my mom or whatever, and just gut it out. It'll be okay. Ignore it. You're a great person. Don't let them get you down. And some of that's great, but you're paying me an attorney rate for an untrained counselor opinion. So later we got much better at identifying when we needed to recommend counseling for people or divorce coaching versus, hey, this is a legal problem that I can solve. And then there's all these other problems that aren't legal that I can't really solve, that you should go talk to someone else about and save your money. Don't spend the money on me.
Yeah, definitely. We strongly agree. Yeah. Okay, so let's get back to the opposite of my other question. I had said, what are mistakes that people make? Now tell us, title of your book, what can people do to make things get done? Like, how can they actually get it done faster? I know there's a lot that we can't control.
Yeah.
But I'm thinking of one thing in particular. You said that some of our clients' lawyers have not done regarding discovery, but you get to your tips on how we can get this done.
Sure. First, be realistic about your goals. Number one is have a realistic assessment of what can be achieved and know what the range of outcomes is. You're going to need your attorney to do that. If you're not sure that your attorney is telling you the right thing, there's nothing wrong with getting a second opinion. This happens all the time. We do it all the time. It's not expensive, to get a lawyer to look over where you are in your case, maybe look at a draft settlement agreement and talk to you about the situation and say, yeah, this looks fine, or hey, maybe you should consider other options. It doesn't necessarily mean you got to change lawyers. You can hire an attorney confidentially to go over your situation and give you a second opinion or a third opinion about what you ought to do. So that's a possibility.
Pause for 1 second, because I want to jump in and ask you something about that. One of our clients has an attorney who specifically told that person, I don't want you working with anybody else. Like, I don't want you getting help. And I said, that sounds very off.
That's fishy.
Yeah. Okay, good.
I mean, if you don't have confidence that your recommendations are good, why would you say that to somebody unless you're worried about what they're going to find out from someone else?
Right?
I mean, there is some truth. The old joke is 3 lawyers will have 3 different opinions about something. Okay, there's some truth to that, but it won't be that crazy. I mean,
it wasn't even another attorney. It was just like working with a divorce coach. And I was thinking, that's like saying don't work with a therapist.
That's really suspicious, suspect. If they're saying don't work with a coach, that's old-fashioned thinking, and that means somebody that's afraid somebody will second guess their opinion. And there's nothing, if you believe in yourself as an attorney, you believe in what the advice you're giving people, then you should be confident that a coach or someone else will be okay, that there's no problem with having sunlight on the subject matter.
Or just support. Like this client is clearly overwhelmed and at the beginning of the process, and I just thought that sounds not right.
Well, the old school attorney thing is that it's a messiah complex. It's like, I'm the only one you should be talking to about your problems. It's like, don't worry, I'll fix everything for you. That kind of messiah thing is part of it's a problem in our business. It's an old-fashioned way of thinking, and it's on the way out, but it's still out there.
Yeah, good to know. I'll definitely share this video with that person if she's not on here right now.
Yeah, sure. I appreciate it. So we'd say, okay, so being organized, so getting your documents in order, getting your ducks in a row with financial information is important. That'll help make things easier for you and your attorney. So tax returns and bank statements and credit card statements, organizing all that stuff is important. Having your thoughts organized when you meet with an attorney about what your goals and concerns are. So that the more you think that through ahead of time, it's money saved on the back end when you're actually sitting talking with an attorney. You're setting yourself up for success. Doing your homework on choosing a lawyer. So the smart people do the research. Yes, they might get personal recommendations, but they also do their Googling, and they look at Google reviews, and they read articles by that lawyer and try to get a feel for that person's style to make sure that fits with what they're looking for. Also, understanding the right process for your case. So maybe your case is good for collaborative practice or mediation or some alternative dispute resolution method. So understanding, are we the right couple for that? Is my divorce suitable for that? Or do we need to go to court? And sometimes you do. Sometimes the process is not good for alternative dispute resolution, or it's not suitable for that. So understanding those differences, that's something you need to talk to a lawyer about. And getting some advice from an attorney and a divorce coach will give you some idea as to what process to follow. And so you don't get down using the wrong tool for the job.
Okay, I know there was one thing you had said that I want to make sure you talk about, and that's with discovery, where let's just say we have a client whose lawyer is saying, well, they haven't submitted their stuff, so we're not going to submit ours.
Yeah.
You know what I'm talking about, right?
Thank you.
Yeah.
I was not exactly sure you meant yes. So don't do what they do. Don't stoop to their level. So that's great advice. With discovery, don't play games. Get your requests out to ask for their stuff, and then get your stuff out. The earlier
even if they don't cooperate. Okay, why? I mean, I know why, but tell our audience.
So because, well, we can talk about the meta case. Number one, we'll talk about that in a minute. So, and I'm not dealing with Facebook now turning into Meta. We'll talk about that in a second. But so there's a reason to be sort of the good guy, and that's what I'm going to get to with the Meta case. But I would voluntarily give documents to the other side. even if they haven't sent a discovery request yet. Why? They're going to ask for it anyway. So we might as well get on our horse, get on our little horsey and ride and get them the information, because we know the request is coming. The sooner that I get that stuff out, the sooner I can tell the judge, if there's a court in this process, Judge, I gave him all the stuff. So much time is wasted in discovery. Discovery is the process by which we exchange information in a litigation case, or well, really in any case. We're exchanging documents and financial information about the children, and that can turn into a grind. And the part where the clients can help is giving that information quickly to their attorneys and helping the lawyers be organized with it, making sure that it's getting transmitted to the other person right away, the other lawyer. There's no reason to wait, because you're going to have to turn it over anyway, and you don't want to be the reason that the case is slowing down. Furthermore, if you don't turn over the information timely, they can bring motions and spend time and money in court bashing you for that and making you out to be the bad guy because you haven't turned over the information, also building delay into the process. Judge, we can't set a trial date yet because we don't have the tax returns from 2021. Oh, gee, Judge, we don't have the bank statements from Chase, account number blah, 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 for 3 years ago. And the law says they're entitled to that stuff. And the judge in my jurisdiction in Illinois, they won't set a trial date until all those ducks are in a row. And I'm guessing that's pretty similar in a lot of other jurisdictions.
Yeah, of course. Yeah. And I mean, I'm thinking with discovery, one common thing we see that was in my own case and many of our clients is the other side gives a bunch of stuff that's irrelevant. They'll say, we complied, they'll give like 3 copies of the same thing, and they leave out pertinent bits of information, and you're still waiting. How do you explain that to the judge? You just say, they gave us 3 copies of the same thing and forgot to give us the main stuff that we're asking for. Or not forgot, but didn't.
Good question, and that happens all the time. The best device for that is, well, there's 2 things. One, you have a remedy in the court process by filing a motion. There's different states have different rules, but they're similar. And the rules are that the lawyers are supposed to talk to each other, try to work out their differences with discovery. Then failing that, and if they haven't complied, they get like another chance. And you confirm that discussion in writing. Then you file what's called a motion to compel in Illinois. That's to force production of the discovery stuff that's missing. So you're supposed to identify what they didn't give you, ask them for compliance, give them some time. And different states have different rules, but the concept is the same. File a motion, ask the court to force them to turn it over. Then hopefully the judge agrees with you and orders that the stuff gets turned over within a certain amount of time. And you wait again, and they turn it over, and you make sure they've complied. That's one mechanism. A more efficient mechanism a lot of times is sending a subpoena to the holder of the records and just end run, go around the party entirely. Maybe they actually don't have the documents. They might be a messy record keeper. They might not have the stuff, or they're lazy. They don't want to go to the bank and download the PDFs from the bank. Sometimes it's just easier to send a subpoena, and it's less expensive to send a request directly to the bank or the financial institution, and they'll produce the stuff. And they know it's a court order. All those companies have systems in place and personnel for the specific purpose of responding to subpoenas. And
is that the kind of thing that you might be able to get costs back for? Because I feel like, when someone delays the process and then you're forced to go directly to the bank and they've had all these opportunities and a motion to compel and they haven't done it.
You might. Judges hate awarding fees, in my experience. So it's very hard to get judges to award fees, even though the statute allows it. So I usually tell people don't bank on it, but it's possible. It's uncommon to get fees back. I usually just find it's easier to send out a bunch of subpoenas because the bank rarely gets it wrong. The banks usually send you everything you want, and it's just easier that way. So that's my, my suggestion is avoid the hassle entirely and just go right to the provider. Another tool that can be effective is a deposition. So I normally don't advocate for more litigation, okay? I'm usually advocating for the most efficient thing possible. And generally we take very few depositions. Usually the documents tell the story in most of these cases, except in custody cases where there's a lot of sort of eyewitness testimony, you need to talk to people. But with financial stuff, a deposition can be very effective to put the person in the chair, put them under oath, and ask them questions about the finances. So you'll find out things you might not know from the documents, and also making them sit in the deposition forces them and their attorney to actually focus on the case. When they have been blowing it off, well, now they know you're going to ask them questions under oath. It starts to get serious, and they can't just blow it off and say, I don't know, I don't remember for everything.
Mm-hmm. Oh, that's a really good point.
Your lawyer's going to stick documents in front of them, at least some of them, and ask questions, and they need to answer those questions. So usually the deposition prompts people to start looking at the case, and it tends to advance the ball. So if you have somebody that's really recalcitrant or they're not budging on discovery, sometimes a useful tool is taking a deposition.
Oh, that's great. That's really good to know. I never thought of it that way.
You know what, too? A lot of depositions turn into settlement conversations because people hate depositions.
Uh-huh.
Oh, I mean, I can't tell you how many depositions we've scheduled where a lawyer in office will say, yeah, we settled it. Like, really? You know, they came in for the deposition, they had a coffee, and now everybody's in the room for the first time. The lawyers, the parties are all sitting there, and depositions are yucky. Nobody likes them. Some lawyers might like them, but most people don't.
They take hours.
Yeah, and they're sitting there and they're kind of like, you know, they finally started thinking about the actual case, and they talk to the lawyer about it. And now people, maybe they start talking. And it's sometimes a deposition works miracles to break a logjam.
All right, that's great. I'm definitely going to share that bit of news with our people. All right, so another little thing that you mentioned the last time we talked was something that you do which can create a wedge between opposing counsel and their client, so your ex, because we know that they often hire people just like themselves, and we feel like they delay the process and lie, and it becomes really hard, and you feel like saying, doesn't that person's lawyer understand that they're lying? Like, why don't they make them listen? So what can you do? If you were my attorney, what would you do to draw a wedge between my ex and his attorney?
So I'm flipping through my book to find the chapter where I talk about it. You're giving away all my trade secrets in this.
Sorry.
No, but it's really not necessarily driving it. I guess one effect may be to drive a wedge between the attorney and the client. The goal is really to educate the client, the opposing client in the case, because if you suspect that the lawyer is either the lawyer just might not be that well informed about divorce in general. They might not be a person who does a lot of divorce work. They might not understand the law, or they could be big jerks. You know, there could be a whole spectrum of reasons why the lawyer's not educating the client in the realistic range of outcomes, like I talked about, and the realistic cost to get there. And so you're churning and churning and churning, and the case is grinding on, and everybody's spending a ton of money. And you know, you're getting worried as the lawyer on one side, and your client's getting worried because they're writing all these checks, and the case is going nowhere. And the other lawyer doesn't seem to realize that we're going to spend a fortune on this case to no good, to no avail, like to no good end. So the thing that I've done in the past in these cases, it doesn't have to do it very often. Sometimes you can pick up the phone and get through to the other attorney and say, look, I think we're running into trouble here because you realize that the remaining size of the estate, the money is X, and our fees are already Y, and they're going to be Z. If we go to trial, it's going to be this much more time and this much more money, and we're both going to get bad reviews on Google from our clients. Is that really what we want to do here? Is that the right thing for the clients? And sometimes you can talk to a lawyer and they'll say, gee, I didn't think of it that way, or, you know, I don't know, maybe they'll talk to you about it. But if you have somebody who's recalcitrant and you feel like they're just not listening, they're not paying attention, then
that's all of our people here. That's what we're dealing with.
Yeah, you're dealing with World War III, like the swamp creature I talk about in the book.
Right.
Then the way to address it is to find a way to communicate to the other spouse about the realistic outcomes at trial, compared to the settlement offer that's on the table and the realistic cost to get to the trial versus the settlement. So what you're doing is, I always call it showing them over the cliff. You're kind of like holding them and saying, you want to look over the cliff? Take a look. It looks scary, right? Well, for whatever reason, the other party, maybe the other lawyer, hasn't shown them over the cliff yet. They don't know how bad it can be. So you can write a letter or an email or something that's a settlement offer. It details out what your terms are. Here's what we're going to offer, blah, 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 blah. And you compare that with the realistic outcome at trial. And you've got to be honest with yourself. You can't BS this as the lawyer or have pie in the sky, because the other attorney will shoot it down immediately and your credibility's shot. You're already taking a bit of a long shot anyway, because you're kind of sending a message to the other lawyer and client. So my goal with this communication is to scare the other lawyer a little bit into thinking about themselves, like, hey, this isn't going to turn out as great as you think it is. And number two, make them understand, I know the score, like, we know what the realistic chances are, and our offer is good. Like, here's in the letter or the email, here's the realistic range of outcomes. You lay it out. Here's what the judge is going to do, blah, 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 blah. You got to be honest about the high and low. Our offer is in the middle there. It's within that range. Here's our offer compared to what the court's going to do. Now, you don't always have a crystal ball. And sometimes this doesn't work in a black and white situation, or they're binary situations, like somebody wants sole custody, somebody wants joint custody. You may not know until you have that battle and have the testimony out there which way the judge is going to go. A lot of judges are pretty coy about what they think about with respect to custody. They're reluctant to tell you anything until they hear all the testimony, which makes sense. They shouldn't tell you until they hear the testimony. So sometimes with these diametric opposed cases, it's going to be important to let people know that you don't know for sure. But a lot of times we do know within a realistic range what's going to happen. So you lay out the range of outcomes. This is our offer right inside that range. Here's what it costs if we go all the way to the distance in terms of time and money. Add that to the money you already spent. And you're showing the person that it isn't worth it.
Yeah, I mean, that's, I think, what happened. I think that's what my divorce attorney did. I didn't realize that that's what he was doing, but that's what he did after the full year, where 2 weeks from trial, from when we, because Connecticut gives a full year once you file, and then they set trial date, where it was like, okay, this is what it's going to be. I would do better in court. We can spend another $50,000 minimum and another year, but it's still probably going to be this. And that's when we settled.
Yeah, you don't have to do it very often. It's once in a blue moon, you run into a lawyer who's just not, they're just a brick wall. You can't talk to them. They're not accepting any settlement negotiations. You're going nowhere, and you're in the middle of a trial, and it's like this bottomless pit. And it's frustrating because you know what the outcome should be, or certainly within a range, and you're spending down the marital estate. The parties are grinding away cash at a tremendous rate. A day of trial is, and the cheapest, it's a $2,500 proposition. It could be a $5,000 proposition each
Here
day.
it's 5,000. Yeah, here it's at least 5,000.
So keeping that in mind, understanding you're gobbling up money at an unbelievable rate, comparing that to the range of outcomes is so important. And so you're basically doing the cost benefit analysis for the other lawyer. And what happens is when you send that settlement communication to the other attorney, they might filter it. They might try to keep their client in the dark about it and say, oh, we got the settlement offer, and they might retype it in their own email or something and not send the rest. But guess what? If their spouse says to them, hey, Rafe sent this email with all this stuff about what a trial court might do and a settlement offer, don't you think that client's going to be real curious? And aren't they going to ask their lawyer, hey, can you send me a copy of that email? I'd like to know, because the lawyer has an ethical duty to share all communications. Yep. So they can't really filter it. So you kind of use that leverage to your advantage to help negotiate. Now, the lawyer may just still stonewall and say, forget it, or convince their client that I'm full of crap, but you got to make an effort.
Right. Yeah. All right. So I'm just looking at the time, because you and I always go over, and we've got like 3 more minutes. Can you do the cost benefit analysis and just say what that is in like the next 3 minutes or so?
Sure. So the crux of the book of I Just Want This Done is keeping the cost benefit analysis in mind always about your goals. So understanding what your goals are, making sure they're realistic, comparing the benefits to the costs. So, and understanding that the costs are far greater than just legal fees. Few people add up the true costs of a divorce. So the true costs include the fees. They include emotional costs to you and your family. They include cash burn rate. So while you are getting divorced, everybody spends more money. Not just on, they're not paying, not beyond the lawyers. They're buying clothes. Somebody's living in an apartment. They're going out to dinner more because you're not doing shared meals. So you're going out to eat. You're buying meals for the kids when you used to all eat together at home, maybe. So there's increased expenses. And you're doing maybe some activities with the children that cost money. So you're burning more cash as a couple along the way. And maybe somebody's having a midlife crisis wrapped into it. So they're buying fancy clothes and they're buying a new watch. And there's not much you can do about that. It could be getting a little bit out of control. If it's excessive, you can maybe bring a motion. But in any event, you're spending more money. So you've got fees, emotional costs, cash burn rate, and you've got the damage to your career. You're impacting your job because you can't think straight. You're busy with thinking about your divorce sometimes. That's impacting your career development if you have a job and a career. The other cost is opportunity cost. And that really is talking about what are you missing out on? So because this divorce is taking 1, 2, 3 years, what could you be doing that's better than this? Probably a lot. Your kids moved out of state because they went to college somewhere else. Maybe you could move to an apartment that's by where they are. Maybe you could start another career now that you're done with the divorce. Maybe you could date somebody that you'd like to be with instead of being around somebody who's making you upset. So there's opportunity cost. And that's a cost that is sort of the overarching one. So what else could you be doing?
Yeah.
So weighing all of those costs against what's, knowing that that's being spent while you're getting from A to B is important.
Right. So it's not just money, it's your time and your energy.
Yes.
Especially. All right. Excellent. You did it. So thank you.
Thank you.
Thank you so much, Raiford, for coming back again. And I'm sure this won't be our last, interview together, and full of information. You gave a lot of good tidbits that I'm going to definitely share. And I always learn things during our conversations as well.
It's always a pleasure. Thank you for having me. And I appreciate everybody in the audience. Thank you for following, and share, subscribe to Been There, Got Out. And I'm at Raiford Palmer on Instagram, Facebook, LinkedIn, TikTok. I'm all over. If you just Google Raiford Palmer, you'll find me. Thank you very much.
Yeah, watch him on TikTok because you have a lot of videos on TikTok.
Yeah, thank you.
And YouTube for that library of educational stuff.
Starting to put stuff on YouTube at STG Divorce Law. Thank you.
All right. Take care, Ray.
You too. Thanks. Bye.
Bye.